Let's jump straight into a cornerstone of WTO jurisprudence, the Appellate Body Report, WT/DS246/AB/R, better known as the EC Tariff Preferences case. If you're prepping for your international trade law exams, you're going to want to grab your notepad for this one. We're going to completely deconstruct the European community's generalized system of preferences, dive deep into the fierce doctrinal battle over what constitutes an affirmative defense versus a standalone right, and really master the strict allocation of the burden of proof under international trade law. Let's get into it.
Here is our roadmap for mastering this case. 1. The drug arrangements dispute. 2. The panel's initial findings. 3. The EC's legal appeal. 4. India's rebuttal and defense. 5. The enabling clause as an exception. And 6. Redefining non-discriminatory treatment. We'll use an appellate IRAC-style breakdown to make sure you have this perfectly structured for your exam.
Section 1. The Drug Arrangements Dispute and Understanding EC Regulation 2501/2001. We've got to establish the facts that actually triggered India's legal challenge in the first place.
At the very heart of this dispute is a legal mechanism known as the enabling clause. Officially, it's titled the 1979 Decision on Differential and More Favorable Treatment. Now, what does it actually do? It basically allows developed countries to grant non-reciprocal, generalized tariff preferences to developing nations. In plain English, developed countries can charge lower tariffs on imports coming from developing countries, and they don't require those developing countries to lower their own tariffs in return. This is a massive, massive departure from your standard reciprocal GATT obligations, and it is put into practice through what we call a Generalized System of Preferences, or GSP. So the specific legal instrument we're looking at here is the European Community's Council Regulation No. 2501/2001. Under this regulation, you've got general arrangements that apply to all listed beneficiaries, and that includes India. These provide for the suspension or reduction of duties. But the EC also created these special drug arrangements for 12 very specific countries. We're talking about nations like Bolivia, Colombia, Pakistan, and Peru. Under these drug arrangements, those 12 specific countries get additional, superior duty-free access to the EC market for certain sensitive products. So picture this. India is receiving only the standard tariff reduction, while Pakistan, for example, is getting complete duty-free access for the exact same products. India looked at this and claimed, hey, this disparity violates the core most favored nation principle found in GATT Article 1.1.
Moving to Section 2, the panel's initial findings. Before we tackle the complexities of the appellate body, let's quickly establish what the lower panel originally concluded about this tariff disparity.
The panel took a really strict approach to the burden of proof here. First off, they ruled that India successfully established a prima facie case of an Article 1.1 violation. Why? Because the EC was treating like products unequally. Boom, this instantly shifted the burden over to the EC to legally justify this discrimination using paragraph 2A of the enabling clause. The panel ultimately concluded that the EC failed. They failed to demonstrate that the drug arrangements were justified under the enabling clause, and they also failed to justify them under the GATT Article XX health exception. So the bottom line at the lower level, the EC was found to have nullified or impaired benefits accruing to India.
All right, Section 3, the EC's legal appeal. This is where the clashing arguments really begin and build into a massive legal showdown. The EC appealed, and they aggressively challenged not just the procedural burden of proof, but the fundamental legal characterization of the enabling clause itself.
Now pay close attention, because the EC's primary claim of error on appeal is absolutely essential for your exams. The EC argued the panel fundamentally misunderstood the enabling clause. You see, the panel categorized it as an exception to Article 1.1. But the EC fought back hard. They argued the enabling clause is actually a positive rule that establishes obligations in and of itself. They called it a standalone lex specialis, basically a special regime that applies to the absolute exclusion of the more general rules of Article 1.1. Because of this, the EC argued it was actually India's burden to prove the measure violated the enabling clause right from the start, rather than the EC having to invoke it as an affirmative defense.
To back this up, the EC pointed straight to the object and purpose of the WTO agreement. They argued that the enabling clause is, and I quote, the most concrete, comprehensive, and important application of the principle of special and differential treatment. Their point was that characterizing this special and differential treatment as a mere exception kind of implies that helping developing countries is a violation of normal rules, rather than a fundamental, baked-in goal of achieving effective equality among WTO members.
And the EC definitely didn't fight this battle alone.
Several third participants jumped into the appeal to support the EC's stance, most notably the Andean Community, Costa Rica, Panama, and the United States. They argued that preference-granting countries absolutely must retain the flexibility to address specific objective development needs. The U.S. made a particularly interesting point, likely protecting their own GSP flexibilities, let's be honest. They argued that placing the heavy burden on developed countries to constantly defend every action taken to benefit developing countries would just create a massive disincentive to grant these preferences in the first place.
Okay, Section 4. India's rebuttal and defense. How do you defend the MFN principle against that? Well, India mounted a rigorous textual defense to maintain the panel's allocation of the burden of proof.
India brilliantly countered that whole lex specialis argument. They argued that developing countries never waived their fundamental most favored nation rights ab initio, meaning from the very beginning. Instead, India took the position that Article 1.1 and the Enabling Clause actually apply concurrently. The Enabling Clause grants a conditional right. A developed country must explicitly invoke it as an affirmative defense if their measure gets challenged. It doesn't just magically wipe away Article 1.1 the second a preference is granted.
India really stressed a critical foundation of international trade here. Article 1.1 is the primary basis for WTO trade. It guarantees formally equal treatment. Therefore, as an exception, any derogation from this MFN principle has to be strictly construed and explicitly justified by the responding party invoking the exception. India pointed out, quite rightly, that the Enabling Clause nowhere specifically states that developing countries just waived their MFN rights against each other.
And India had backing too, specifically from third participant Paraguay, who helped drive home a really important historical point. They noted that earlier, politically motivated special preferences were specifically replaced by the generalized systems of the Enabling Clause. Why? To prevent exactly this kind of cherry-picking. The whole historical goal was to ensure that if a developed country granted tariff benefits to one developing country, those exact same benefits must unconditionally flow to all developing countries.
Moving into Section 5, the Enabling Clause as an exception. Now, this is where it gets really fascinating. Let's look at how the appellate body meticulously deconstructs the treaty text to resolve this profound clash of legal theories.
To answer the critical question, is the Enabling Clause a standalone right that entirely excludes Article 1.1, or is it merely an exception? The appellate body turned to the customary rules of interpretation, specifically those codified in Article 31 of the Vienna Convention on the Law of Treaties. So they're looking at the ordinary meaning of the text, in its context, and in light of the treaty's broader object and purpose.
And you know what? The appellate body found their answer anchored in a single word in paragraph 1. It is honestly amazing how multi-billion-dollar international trade regimes can hinge on basic grammar. But read this carefully. Notwithstanding the provisions of Article I of the General Agreement, contracting parties may accord differential and more favorable treatment. By isolating the ordinary meaning of that one word, notwithstanding, they unlocked the entire case.
Let's trace their exact sequence of logic, because if you're taking an exam, this is exactly what you need to write down. Step 1, they defined notwithstanding to mean in spite of or without regard to. This means paragraph 1 permits members to provide favorable treatment in spite of the MFN obligation. Step 2, they reviewed the overarching WTO objectives. They found that while the Enabling Clause absolutely pursues positive WTO goals, those goals can still be pursued through measures characterized legally as exceptions, kind of like how environmental goals are handled under Article X. Step 3, because it operates in spite of the general rule, legally speaking, it is an exception.
So here is the crucial takeaway for your exam prep. The appellate body upheld the panel's finding. The Enabling Clause is indeed an exception to Article 1.1. And because it's an exception, the allocation of the burden of proof is incredibly strict. The complaining party, which was India here, only needs to raise a claim and establish a prima facie Article 1.1 inconsistency. Once they cross that threshold, the heavy burden of invoking the Enabling Clause and justifying the discriminatory measure shifts entirely over to the defending party, the European communities. Finally, Section 6, redefining non-discriminatory treatment. Having settled that whole burden of proof issue, we have to examine the fierce substantive debate over the actual text of the Enabling Clause, specifically the battle over how to interpret the word non-discriminatory found in footnote 3.
So, footnote 3 requires that GSP preferences be generalized, non-reciprocal, and non-discriminatory. The EC claimed that differentiating based on unique developmental burdens, like, say, massive drug trafficking, is completely non-discriminatory as long as the criteria are objective and the response is adequate. India, on the flip side, argued for strict formal equality. They argued non-discriminatory mandates identical competitive opportunities for all.
To India, treating developing countries differently is discrimination, plain and simple. End of story.
The EC, and they were supported heavily by the Andean community here, strongly argued their case based on the harsh realities of development. They pointed out that drug production and trafficking have unparalleled, really unquantifiable implications for economic development. Therefore, offering targeted tariff preferences is an objective, proportionate response. It provides alternative, licit activities to farmers. Treating a country that is absolutely ravaged by drug cartels identically to a country without that specific burden. The EC argued that's a total failure to address real, tangible development needs.
But India warned of the immense dangers of this approach. They argued that allowing developed countries to conditionally grant tariffs based on a developing country's domestic situation diverts vital trade opportunities. It creates massive trade diversion away from other developing countries. Think about it. If Pakistan gets duty-free access for textiles because of drug arrangements, India instantly loses competitive ground. India stressed that introducing this kind of conditionality utterly destroys the legal certainty of the generalized system of preferences, essentially turning it back into a political tool for developed nations.
So, as you prepare your essays on this monumental piece of WTO jurisprudence, you really have to critically evaluate this exact tension. Does true equality mean blind, identical treatment to prevent political abuse? Or does justice require the flexibility to recognize objectively different struggles? Mastering the tension between the procedural burden of proof and this deep substantive debate over non-discrimination is absolutely your key to acing any question on WT/DS 246/AB/R. Keep analyzing those texts, and good luck on your exams.